All rise. Fourth District Court of Appeal, First District is now in session. All those with cause, please draw nigh. Give attention, you shall be heard. Again, God save these United States, the great state of Florida, and this honorable court.
Please be seated. We have two cases on the docket this morning. We're taken in the order that they appear. After the first case, we're going to take about a 15-minute break. We invite all the lawyers to join us for coffee right around the corner. Unfortunately, we can't invite all the students. We don't have enough coffee. You can blame it on Coastal. I think we only came up with a little bit. So only the lawyers. After the second case this morning, we are going to stay on the bench and answer questions from the students about the court. Anything you want to talk about except the individual cases that we're hearing today. We can't talk about that, but we'll be more than happy to respond to any questions from the students. I would suspect that it's probably going to happen sometime around 10:30 or so. Are both sides ready on the first case?
Yeah.
Appellant may proceed.
May it please the court, Dinah Stein on behalf of the appellants, Dr. Joseph and the Borland-Groover Clinic, and I would like to reserve 2 minutes for rebuttal.
Okay, I will try to remind you the clock's in front of you.
Thank you, Your Honor. And the defendants are here today contending that they are entitled to a new trial on several grounds, as well as reversal of the attorney's fees award. And of course, the first ground raised in the brief is plaintiff's ambush of the worst kind on the defense during the cross-examination of the defendant, Dr. Joseph, with a previously undisclosed medical record of Mr. Niosi, whose care and treatment was not at issue in the case. This was a record that had never been disclosed to the defense, provided to the defense, hinted at.
You don't really mean disclosed because it was your client's medical record.
That is correct. He constructively had knowledge of it in the sense that it was his medical record.
Well, his office had actual knowledge of it.
His office had actual knowledge of it.
Their complaint is that they didn't list it as an exhibit in pretrial stipulation.
And that is the complaint, and not only that, but this is something that the defendant could not have legally given to his counsel under federal and state privacy laws.
Because of HIPAA.
Absolutely. That would not have been permitted. And so the defense lawyer was not on notice of this 17-page medical record.
You're saying 17 pages, but didn't one page come in?
That is correct. One page went in, but I have to describe the circumstances because that's very relevant. 17 records is what was produced during the cross-examination, and that is what was given to the defendant and defense counsel.
Question.
Yes, Your Honor.
You used the word ambush about 10 times in your brief. That's a very colorful word.
Yes, Your
I don't know
Honor.
how persuasive it is, quite frankly, except to the jury, but it's colorful. You're not at all concerned with the fact that the jury would have been left with your client's testimony, which was not true, but for this time record having come in?
That's how it was presented.
Testimony concerning the absolute inerrancy of the chart would have been in the jury's mind, but for this evidence coming in showing that the chart was not inerrant.
That's correct, without the ability to rebut why it was.
You're not hearing my question.
Okay.
You wouldn't have been concerned if the jury had been left to rely solely upon your client's testimony, which was not true. That wouldn't bother you at all?
Without conceding the non-truthfulness, that's correct. Yes. It wouldn't have been prejudicial, and we wouldn't be here arguing.
You're still not getting my question. Your client said these time records were absolutely inerrant, and you relied upon that to extrapolate how long it took him to perform the colonoscopy on Mrs. Niosi.
That's correct.
That was not true. The time records are not, in fact, inerrant. Right?
It appears that way with the records.
So what I'm saying is you as a lawyer and officer of the court are not troubled by the fact that the jury would have been left with that inaccuracy in your client's testimony, but for the introduction of this one page.
Well, that's correct. But for that was key to the defense.
I still think you're getting my question. Okay. My question is, your client lied.
I disagree with that.
I'm not saying he intentionally lied, but he mischaracterized the record, the medical chart, his own medical chart, and that doesn't seem to trouble you.
The reason we are here arguing this and not troubled is because it is the defendant's position that there would have been a perfectly good reason for it, because the times, obviously the nurse couldn't be in two places at once.
Did you ask for a continuance?
No, Your Honor.
Did you recall Nurse Richardson?
No, Your Honor.
What's the beef?
The beef is that, first of all, the defense was not even allowed to discuss the record with the defendant. The plaintiff objected to even...
That's why I asked you whether you asked for a continuance. An hour, 2 hours.
No. Nurse Richardson...
You were able to discuss the record after you were surprised and ambushed.
After Dr. Joseph was released.
The problem I'm having is that we're all with you on the non-disclosure. I assume we are. But the TEF, as it's developed, is a little bit more than that. And you look at prejudice, and I'm just asking you what perhaps you could have done to cure the tremendous damage that this ambush did to you, including perhaps taking a break, talking to your client, recalling Nurse Richardson, and you didn't do any of those things.
Well, let me address the talking to Dr. Joseph, because the plaintiff specifically objected to that. He didn't want any chance to rehabilitate Dr. Joseph, so even during the discussions during court, he asked that Dr. Joseph be excused from court and that he be instructed not to have any discussions about it with his lawyer.
So he objected to your request to delay this trial for an hour or so you could deal with this undisclosed matter.
There was no specific request to delay it for an hour or so.
I didn't object to that because it wasn't ever made. The request was made by your trial counsel.
Trial counsel requested that there be a break so he could become familiar with the record. The court did come back at one point to try to reconvene, which he said he needed more time. Now, he did object the next day after he had more time to look at the record, just to show the court that, first of all, there was a page missing. It just wasn't sufficient time to become familiar with the record.
But he never actually requested a continuance.
No, Your Honor. No, he did not. This could have been avoided had the plaintiff complied with the court's pretrial order.
Well, it could have been avoided if your client hadn't misstated the facts on the stand, too, as Judge Kahn has already pointed out.
Well, the client at the time was in good faith, going by the only record that really had been relevant during the proceeding. Now, one of the things that defense counsel brought up during closing, and which may have been a point, in other words, it was too late to reopen discovery. This very well may have been a software problem, because again, nobody really knew how this worked, how when Nurse Richardson went and pushed buttons, first of all, that Dr. Joseph repeatedly said, you've got to ask Nurse Richardson about this, and frankly, she had already testified, and the plaintiff, for whatever reason, didn't ask her any of this, even though her initials were on it. But the other problem with this
seems to be, counsel, with all respect, like I said, I think everybody's with you on the non-disclosure part of it, but you seem to be overlooking this minor little point that somehow the plaintiff is supposed to anticipate that your client's not going to tell the truth. How are they supposed to know that? How are they supposed to know he's not going to say, I think these records are generally accurate, but sometimes they're not? How are they supposed to know?
He was supposed to know because that was core to the defense. I mean, really, this was a circumstantial case where there was never any direct evidence of negligence. So, of course, the plaintiff's point was that he must have been rushing and therefore exerted too much pressure during the procedure. And the defense
that's not my question. They were
Yes, Your Honor.
supposed to anticipate that your client was going to take this ironclad stand, which turned out to be false, on the timing in these two operating charts. How would they know that?
They would know that from Nurse Richardson's testimony, and she had the exact same testimony.
When did she testify?
She went through those records as well. It was stated the day before.
And the discovery deadline was passed by then. The jury was convened and the trial was going.
That's correct. And I would submit that if this was really a search for the truth and what really happened, this would have been disclosed so that the defense could fairly open the discovery or perhaps...
But counsel, they could have never, this record would have never been relevant but for your client's testimony, right?
I disagree respectfully, Your Honor.
This record would have been relevant in the case in chief?
If the case in chief was in fact that the defendant...
Counsel, you're telling us that this relevant, this chart, the operative chart from Mr. Niosi, would have been relevant in the plaintiff's case in chief, but for your client's testimony?
Respectfully, I believe the plaintiff was aware of the defendant's
That's not my
defense.
question. Again, my question is, my point is that this chart, however damaging it may have been, and I think we're with you on that too, would not have ever been relevant but for you talk about the plaintiff setting a trap, and I saw that as normal cross-examination. Boxing in your client to stand on the inherent accuracy of the record. They didn't. For all they knew, he was going to say, well, you know, sometimes these are not 100%. That doesn't change my testimony.
Right, Your Honor. Again, Dr. Joseph went by what he thought was an accurate record.
I'm more concerned, if I understand the pretrial order in this case, it required that the parties list all exhibits they intended to use, including possible rebuttal exhibits, and that wasn't done in this case. This clearly was not listed. I'm more concerned about the fact that when this occurred, trial counsel for your client didn't ask for continuance.
Well, again, the circumstances of this was that...
Because it seems to me that if all of your hypotheses about how this could have been an innocent error are true, with a continuance, you could have determined that, and you could have diffused this ticking bomb.
Well, again, we were at the end of a trial where the relevant witnesses had already testified, for instance, the nurses. So if we had to stop the trial, I suppose, and reopen discovery, I just don't know that this court seemed at all inclined to do that. She allowed this to come in without any discussion.
But surely you can see, at least I hope you can see, that your position would be a lot stronger had you done that, and the trial judge denied your request.
If Your Honor believes so, then
Yeah,
perhaps
I
still don't. Obviously, we still contend that this shouldn't have happened, period, and that this all could have been avoided had the pretrial order been complied with, and then we could have just done discovery in the normal course.
You know, the other thing going on, I'm not sure we've ever required it before, but you talked about subdivision. Well, it could have been software, or it could have been this, could have been that. Can we look at this record and tell that it could have been? I mean, did you ever move for a new trial and lay out, this is what we could have presented?
No, we did not.
I'm a little concerned about that. I mean, I know we haven't specifically required that before, but it seems to protect the record that if it really was something that we couldn't get at the truth, that you'd have a lot stronger case if someone was on the record to say that.
I understand, and I don't know if it would be a 1.54 motion or just a new trial, but it was suggested by the defense counsel in closing. But to the extent the defense then took a record that was presented to it and reopened its own discovery, I would submit that I don't know of any case that does require that, or even consider it.
Either,
but you're correct, Your Honor. That's correct. I'd like to just briefly, I want to touch on two other issues and then very briefly touch on the second point on appeal, which was the preventing Dr. Rex from testifying in regard to his own experience with either splenic ruptures or use of extra force, and frankly, the jury had no way of quantifying the testimony of either expert when the court prevented him from talking about the fact that he had 200 experiences involving more than normal forces with no splenic rupture, as well as other splenic rupture cases without excessive force. And the reason why that was so important and prejudicial was because he has, this world-renowned expert on colonoscopies has performed 30,000 colonoscopies, and this was the experience that was very critical to causation. Thank you, Your Honor. And the plaintiff's expert was a liver expert who the sole experience he had with splenic ruptures were 9 cases referred by plaintiffs. And I would just refer to the Second District's recent decision in St. Joseph's versus Cox, where the plaintiff's verdict was actually reversed based on the plaintiff's
But that's a
experts.
very different case. In Cox's question was the efficacy of this particular drug to prevent stroke or whatever the problem was. And what the second district said in saying that a motion for directed verdict should be granted was that the plaintiff's expert was unable to testify that in fact the drug, in his experience, might be more efficacious than the NINDS study.
That's correct.
That's so different, in my opinion. So the issue in that case was not the plaintiff's expert's testimony. It was the sufficiency of the evidence to sustain the plaintiff's verdict.
That's correct. That's correct. And obviously it's not the same types of case. But getting back to this one, we submit that in order to show causation, which again this case was strictly circumstantial, it was very important for Dr. Rex to quantify his experiences by saying what to the jury what he has seen in his practice. In my very brief remaining time, I do want to address attorney's fees because I think that is absolutely.
You realize this is your entire time. This is not your.
Oh, then I will talk very quickly because this is my rebuttal.
I will, since we've taken up so much of your time and question, I will give you 2 minutes for rebuttal and ask 2 minutes for the other side, please.
I would like to address attorney's fees, and if I need to use my 2 minutes, which I appreciate, Your Honor, I'll try to be very quick. The 2 out of the 3 settlement proposals that the court found were effective, were addressed to multiple defendants with their choice of picking who paid it. The Lamb 3 cases, which I'd like to just cite to the court, Lamb versus the, I can never pronounce the second word, which says you can't make undifferentiated settlement proposals to multiple parties. Then after the court made its decision in this case, the Supreme Court came out with the attorney's title versus Orca case, which says that when you make a single offer to multiple defendants, they still must be able to individually assess.
Well, the deal under Lamb is probably the issue, so unless this change, you really can't do an offer of settlement when you got vicarious like that.
It's virtually impossible.
And I appreciate you can't.
No, it's
You're right.
that is correct, and it is what it is. But here, the defendants even tried to assess what the offer exactly was, and got a letter back making things, frankly, even more confusing because now it was $239,000 for all defendants as opposed to simply the corporate defendants. One other case, Eastern versus Russell, which is right on point. That is from the 2nd District. The Supreme Court denied review. And in that case, the plaintiff did exactly what the plaintiff did here and say, here, doctor, here, professional association, it's a single offer, you choose. And the 2nd District said that is absolutely in violation of the prevailing law and unenforceable. And so we would submit that regardless of what the happens with the new trial, that the $95,000 attorney's fee award be reversed based on invalid settlement proposals. And I appreciate Your Honor's time and the extra time.
So you're going to have about 20 seconds for rebuttal. I hope you do that.
I'll be fast. Thank you.
Thank you. Knack McLeod, I represent the plaintiffs in this case. Let me begin by telling you that if trials were perfect worlds, we wouldn't be here on the first issue. Unquestionably, at the time the pretrial order was submitted and complied with, this document was not in those exhibits. Truth in fact, it could not have been at the time because it was not an exhibit in this case at the time of the pretrial order, or even at the time of the pretrial. In fact, it was not an exhibit in this case until essentially 9 o'clock on the morning right prior to the time that the doctor testified.
Did you reveal it to him at that time?
Did not. I had it revealed to me at 9 o'clock, and the first witness called at that time was the doctor.
See, I got a real problem with that.
I understand.
This idea of ambush, I mean, I knew it was a descriptive word, but this idea of hiding from the other side of documents and not complying with the pretrial state. I mean, if we affirm this, aren't we sending a message? You don't have any responsibility to reveal the documents to the other side. I mean, that's a real problem.
I think I do have that responsibility. Had I had the document, I absolutely would have had the obligation. And frankly, when the document was provided to me on that morning prior to the doctor testifying, I probably should have, in those circumstances, indicated that to Mr. Charles.
And I think it's exacerbated by the fact, and correct me if I'm wrong, you did object to them talking to their witness about the document.
he was in cross-examination, I did object to that. But what I objected to was based upon the fact that I was trying to avoid him coaching on the subject of what occurred.
Well, didn't you invite that by your behavior? It seems to me, okay, we ambush you, and then I'm not going to let you talk to your witness. That seems to be you're just pushing the envelope a little bit further. I want to win. I don't care about professionalism.
My behavior was a choice, and that is, I listened to the doctor testify as I listened to the 3 witnesses the day before, and my clients had drumbeat this issue on these records are not just accurate, but inerrant. And secondly, the doctor then got up and testified in direct examination and in cross-examination that they were split second accurate.
But surely you knew that was going to be the testimony from your discovery depositions. If you didn't, there was something wrong.
With respect to the exact times of the timeout, I don't think that's clear in the discovery deposition. With respect to the time that it took for the procedure, well, the time it took for the procedure, the 11 minutes, that was clear in the depositions. It really was not until the trial, that in the defense portion of the trial, that the absolutes came about with respect to time. And again, absolutely true that had I had the document, I should have complied. Now, we're missing one other issue, and that is I'm approached by the other side, and this was the judge recognized this, Mr. Childs recognized this at trial as well, and that is I'm approached prior to trial and said we're going to do this the old-fashioned way. All impeachment documents we're going to keep to ourselves. Now, they enjoyed that agreement with Dr. Salem when they pulled out deposition after deposition to pillory him on this issue of amount of times he's done this and these other issues, but didn't enjoy it at the time when it came about in their own case after, as you indicated, Your Honor, and that is making this statement very absolute with not one but 4 separate witnesses about the inerrancy of time.
Maybe things have changed in the time since I was last a circuit judge in this circuit. But when I was here, it was very clear from the pretrial order that all exhibits that might possibly be used during the trial had to be listed. And if they weren't, you didn't get to use them.
Still case. Still absolutely case. And the order says here, that was caveated in this case with this agreement that was proposed by counsel for the defendant regarding impeachment documents.
But the agreement wasn't in writing, and there was a disagreement during the trial about what the scope of the agreement was.
There was no disagreement prior to trial. It was announced to the court and then reiterated at the time, and Mr. Childs, to his credit, indicated that they said it was his understanding that that wouldn't apply to exhibits that were sought for introductory purposes.
Well, it strikes me that when you have a pretrial order that's as clear as it can be, and is as clear as it can be for a reason, precisely to prevent this sort of gotcha stuff, it strikes me that if you want to avoid having to comply with that order, you better have something in writing.
I don't disagree with that at all. To contemplate at the time that Art Niosi's records are going to be relevant is the bigger question for me personally and professionally as a lawyer. Did I think Art Niosi's records would somehow be relevant? They turned out relevant because they turned out to be in direct contradiction of 4 witnesses' testimony who wanted to make it clear. And by the way, this was a defense of this issue of speed and the issue of timing. The experts, and these were always battles of experts, got to testify as to the issue of force. They both did. And one expert, if not both, testified that one of the ways that you look to see if there's too much force used is the speed in which the procedure goes. Well, that somehow got bootstrapped a bit into this issue of timing. The plaintiff's case in chief doesn't talk that much at all about the timing of the procedure. It talks about the time of the procedure, the total amount from the insertion to the withdrawal. It's not until you get to the defense case does this issue arise, as I said, in drumbeat consistency with how absolute these times are. I then am in possession of a document that demonstrates that that's absolutely false. I give this individual the opportunity to look at it and amend. He's given not one but 3 different opportunities to withdraw from this absolute statement, and it doesn't. At that point, he looks at it and indicates that it's incorrect, that there's been some incorrectness to it. They could have called Nurse Richardson back. Dr. Joseph did, in fact, testify as to what he thought occurred in the circumstances. And it's the only issue that involved this. Every other document is disclosed.
So you're saying you didn't have the husband's record until that day?
At 9 o'clock the morning of, provided by Niosi, who sat and listened to 3 witnesses the day before. And I absolutely agree with Your Honor's statement. Should it have been? Yes. In the perfect world, and in hindsight, it's wonderful that what I do as soon as I'm supplied with this, prior to the doctor taking the stand, I'm providing it to the child. It's an imperfect way to handle it. But at the same time, to use words, as the court said, so strident as to say classic trap and ambush. I'm not that clever. I'm not so clever as to hold something back and not comply with the order. The fact is, I have it. The doctor testifies. Had the doctor testified, exactly as the court said, that these things are pretty close to being exact, I don't know if it becomes relevant at all. But that wasn't the testimony in the case. And in truth, this is not a Banger situation. I didn't introduce this document in chief. This was used for impeachment. In fact, the 2 cases that are probably closest is one of this court's cases, the Eaton case, which talks about impeachment and the difference with respect to impeachment issues. And that is important. They made the issue. They beat the issue to death in their case in chief. We had a piece of evidence that demonstrated that that was false.
What's the standard of review on this issue?
Abuse of discretion, essentially inaccuracy.
Maybe it's because I know what the practice is of Duval County, but I have to tell you, this document would not get presented out in this circumstance.
And I think that goes to the issue. I think there are certain courts, obviously, as you just indicated, that may not let this in. But the standard is abuse of discretion. And rightfully so, because in the context of what occurred here, and especially in the context of the amount of evidence, with all due respect, I think this was the appropriate decision, and was it helpful to our case? Certainly it was helpful to our case. But is it some sort of intended ambush? Absolutely not. They were given the chance to review the document. They were given the chance to explain. And ultimately, Mr. Childs questioned the doctor and thought fairly adequately rehabilitated him there. They want to think that the entire decision was based on this issue. It wasn't. These are expert opinions, and the expert opinions, I think, control the circumstances. With respect to the limitation of Dr. Rex's testimony, when you don't go to the record, Dr. Rex testified exhaustively about his personal experience, testified exhaustively about how the number of colonoscopies he'd done, the incidence of splenic rupture being so rare. He testified that in his opinion, it wasn't relevant to the amount of force, that he had used force and others had used force. The only limitation of his testimony was when he wanted to talk about very specific patients, 2 of which he observed and 1 of which he engaged on himself. And I objected because I had no ability to cross-examine specific examples because of them and because of these issues, and that was limited. And again, there is broad discretion allowed to trial courts in those circumstances. And with all due respect, again, it was an appropriate use of that discretion. With respect, and it was no different than what Dr. Salem was allowed to testify with respect to these issues either. The jury chose to believe and to find on behalf of the plaintiff, apparently because they understood that the testimony of Dr. Stedman was that it had the greater force and was more convincing in the circumstances. The attorney's fee issue is a bit analogous to 20/20 hindsight, and without trying to be trite or glib, it has acquired confusion.
But on the attorney's fee issue, the Supreme Court has made it as clear as possible that all of these things need to be strictly construed. They have actually just last month, or 2 months ago now, adopted a proposed amendment to the rule made by the Civil Rules Committee that will solve this problem. Maybe it will solve this problem. But it's fairly clear, I think, in the law, as it stands today, that your proposal was inadequate.
The proposal, well, 2 of 3 proposals were upheld. One proposal was not upheld, and that's the one where there was a typographical, an admitted typographical mistake. And that was from Lynn, Niosi, to Dr. Joseph in this case. And in the paragraph,
the law is as clear as it can be that you have to differentiate, even if you've got somebody who's purely vicariously liable. I mean, the law is as clear as it can be, I think.
well, we indicated in the offer that basically we were making the offer to the corporate defendants and that any of them could accept the offer.
But it seems like the opinion, the second district opinion in Easterns, I think they fairly accurately characterized, one of the battle in that case said, look, this is a crazy result. It seems to be dictated, it seems to me that if you were to go your way, we not only have to follow the Supreme Court's decision, but have to certify conflict.
And my recollection is that in Lamb, both Justice Perriente, I think it was then Chief Justice Perriente, maybe not, and Justice Lewis said in a special concurrence, as I recall, look, there's a serious problem here. Rules Committee, please suggest a fix for this. And that's precisely what ended up happening.
I agree. That's what the case says. I think your decision in Clements, coupled with your decision in State Farm v. Nichols, is the best way to look at this. And that is, A, and I don't make this as an excuse, that you can't, there are some ambiguities that can't be fixed. And maybe that it can't be perfect.
But this is not an ambiguity situation. It's a situation where the rule says that each party must be separately identified in an offer made to each party.
It does. It does.
And I'm not going to disagree with you that it's crazy, but that's what the rule says.
And I'm not asking you, but in a way that I am, to stand against the crazy. But the ultimate, the penultimate issue
But the crazy is the Supreme Court, not the State.
The ultimate issue that the Supreme Court had in State Farm versus Nichols is confusion. And in this case, there was no confusion. In fact, counsel indicated that it was my letter. It wasn't my letter. It was counsel's letter to me indicating, here's my understanding.
I don't object to showing the confusion. It seems to me, and I think the opponent was extremely forthright saying, hey, on these vicarious liability cases, you guys are in trouble. But it does seem to me that there is an out, and that's simply to make the proposal to the active court fees cases. You know that.
Well, yeah. And probably we get into the active court fees, or if you recall, that's where the typographical.
Without making the proposal to the employers.
I agree. And in fact, we've been through this issue with releases and offering releases. I'm of the opinion now, don't offer a release.
Well, there's no way to know what the law is regarding releases under that rule, under 442, but I'm going to tell you again, I think on the issue we have here, the law is pretty clear.
It's a marvelous rule that I'm concerned, frankly, as lawyers have done bad things to. At the same time,
What's your paid to do?
not do bad things. At the end of the day, they knew exactly what they could do to settle the case.
they also knew what the law was, and this rule has played out equally against them and against you. I mean,
It has.
defense counsel have tried to make it went off, so they could look at the consortium claim. They can't do it.
Right.
It's nuts.
Well, again, at the sake of being trite or glib, I would ask the court to stop that and to bring common sense to it, because there was a common sense and real understanding of how to settle this case, and they elected not to do it, and there were consequences to it. Thank you. Appreciate it.
You got 20 seconds.
I don't know if this is important to the court, I just want to put it out there, but my trial counsel recollects that in the affidavit on fees, there was review of Mr. Niosi's medical record 2 days before it was introduced at
Let
trial.
me ask you a question, because I think this whole, I'm looking at this case trying to take the perspective of what's going on in the heat of battle, and it seems like the thing that they did in this case, that maybe in retrospect they shouldn't have done, is offer the document. What they maybe should have done is extensively cross-examine your client, show him the document, that'd be okay, and then ask him whether he'd like to retract his testimony. Wouldn't you agree that they had simply done it that way and not introduced the document? Practical result, maybe we could say.
And let me just make sure I understand Your Honor's question. Brought it out beforehand, or?
No.
Okay,
What I
what's
want to
different?
say, box it in, as you say, on the inherent records, and then show him the document, and give him a chance then to impeach himself by saying, well, maybe my records are not that accurate. But instead, what they did in the heat about it was introduce the document. That should be to introduce the undisclosed document. What I'm suggesting is they could have done exactly the same thing through cross-examination.
Perhaps, I believe the court order referred to all documents that were going to be introduced at trial.
That's not what I'm saying.
He's talking about using it to refresh your client's recollection without offering it in evidence.
We would have a weaker point if that's what had happened. I think there would still be a beef based on the fact that he didn't have personal knowledge of Nurse Richardson's
Well, your beef wouldn't be the
acts.
Binger beef, because the Binger beef has to do with undisclosed witnesses and exhibits that were introduced into evidence.
Right, you may be right, Your Honor.
Fairness.
Right, that could be correct, but here
The point of my question is, I know I've noticed you like to concede a lot of things, and I appreciate that and advocate it, but I'm suggesting that perhaps they could have accomplished the same thing with rigorous cross-examination and use of the document short of introducing it into evidence.
Except, of course, if your client had continued to deny that there was any error in the times he testified about, there would be no way to get the contrary evidence that's on the document in without offering the document.
correct.
So he'd have gotten away in that case with continuing to insist that these times are written in stone.
Perhaps if it had gone down differently, it would be an entirely different appeal, and that could be the case. That's not what we have here, because it did go to the jury, in fact, without us being able to rebut it. So unless Your Honors have additional questions, I know I've gone well over, and again, I do appreciate the extra time. Thank you.
We invite the attorneys to join us in the talk room in 15 minutes.